Gallon WLG is a global multidisciplinary law firm that provides a vast array of legal services, including intellectual property. Next. They're represented here by my colleagues, Dr. Damien Calvet, patent agent based in the Montreal Gallon office, Mr. Vivian Desmond, and Mr. Elliot Papadio, based in China office, Ms. Tamara El-Shabi, in the Dubai office. Next slide. For those who don't know me, my name is David Ryan, president of Forpic and co-founder of MVIP. So let's say this next slide, please. So I'm a member of the Quebec Bar, registered trademark agent in Canada, the US. I'm the sitting president of Forpic. I've published a book chapter on the crossroads between investment and IP, and I've also appeared before a few parliamentary committees on matters related to intellectual property, including science and research last year in 2023. And we've also participated in some of the consultations with respect to the science, research, and economic development tax credits, as well as the innovation patent boxes. So next slide, please. So who is Forpic? Forpic is a 20-year-old not-for-profit organization that promotes IP awareness across Canada and supports dissemination of IP-related content to its subscribers and its members. In July 2024, Forpic ascended to a permanent observer status of the World Intellectual Property Organization, WIPO. WIPO is a UN agency whose mission is to establish comprehensive, well-balanced, and effective system for the protection and enforcement of intellectual property rights. Forpic is currently calling for IP-related topics that you, the participants, would like to hear from. We would like to be able to address them at our next forum in the month of November 2025. So please do send us your proposals. Next slide. MVIP Solutions is a business advisory project management office designed to maximize value through IP and business strategy. It calls upon external legal and accounting experts to create optimized IP assets while using grants, incentives, and tax credits, including patent boxes, as flywheels to maximize value. And the last organization that will be presenting with us today is the Canadian Trade Commissioner Services under Global Affairs Canada, which is represented today by my colleagues, Mr. Eric Futin and Mr. Frédéric Barillon. So I'd like to thank all of you for being here today, and I must emphasize to the participants online and in person that it is very rare that you can have this wide range of knowledge and services on one panel and on one platform. You're in for a treat. As it's customary in Canada, we'll begin the webinar with the land acknowledgement. So we would like to begin by acknowledging that Forpic is located on the unceded Indigenous lands. The Kanien'kehá:ka Nation is recognized as the custodians of the lands and the waters on which we gather today. TOTAK Montreal is historically known as a gathering place for many First Nations. Today, it is home of a diverse population of Indigenous and other peoples. We respect the continued connections with the past, present, and future in our ongoing relationships with Indigenous and other peoples within the Montreal community. I would like now to present to you Mr. Eric Futin of the Canadian Trade Commissioner Service.
Merci, David. Thanks for the introduction. I'm really happy to be here today because I'm passionate about IP, innovation, globalization, so international, like going abroad with IP is something that would make me like waking up in the morning. So that's really nice to have to be here today. So to start with, we know that Canada, we are like 0.5% of the global population. But 99.5% of our potential consumers are outside of Canada. So growing globally is often just part of the business growth cycle. And that's where we, the Trade Commissioner Service, comes in. But who are we? I know that it's a term that you're not really knowledgeable about, but as they say in Ottawa, we are the most hidden gem in Ottawa. So we have to work with you. So basically, we are your global team on the ground, an unbelievable network with offices across Canada and around the world to help Canadian companies like you grow globally. We'll be supporting Canadian companies in their desire to expand abroad for over 125 years. With on-the-ground network of more than 1,000 trade commissioners serving 10,000 clients in over 160 locations around the world and 6 regional offices across Canada, we have a global network that can support companies, particularly SMEs, to scale internationally. Canadian companies that we are serving are not just companies, they are the TCS clients. So next slide, please, if we want to go. Thank you. So to provide a brief context of how important is IP, which is not a view of the mind, but a central pivot to innovation and economic growth, we can see on this graph that intangible assets, which include largely IP, have been constantly growing on importance over the last decades. They are now accounting for 90% of all business value, compared to only 68% 25 years ago. For Canadian SMEs, considering IP protection is quite beneficial, as SMEs holding IP are 2 times more likely to experience high growth, 2.5 times more likely to innovate, 3 times more likely to expand domestically. But the most important thing for our discussion today, they are 4 times more likely to expand internationally. So the bottom line is, if you want to reach your international objective, protecting your intangible asset is mostly a sine qua non condition. Next slide, please. The market value of many successful companies is enhanced by their intellectual capital. This comprises of a blend of efficient operation and the management of the unique ideas that are translated into intangible assets such as inventions, creation, and brand. Is then a significant contributor to value, not only by the firm itself, but also by financial institutions. I invite you to look at the recent CPO's, the Canadian Intellectual Properties Office, IP Canada Report 2024, which includes a Canadian snapshot of research to be included in the forthcoming study published by WIPO, highlighting typical IP use and ownership among Canadian firms, emphasizing the use of patents and trademarks as security in financing operation. Next up, you're trying to do that. Sorry. So Canadians recognize the importance of IP to economic growth and productivity. Canada ranked 14th in WIPO's Global Innovation Index 2024, continuously improving over the last 5 years and continuing its presence among the top 20 ranked economies since 2010. It also improved its ranks to 8th in innovation inputs while keeping its 20th position for the innovation output rank. IP rights like patents, trademarks, and industrial designs are key in contributing to a country's innovation output. Enhancing Canadians' use of IP rights both domestically and abroad is critical for success in a large economy that is increasingly driven by the large open economy that is increasingly driven by intangible assets. So next slide, please. Oh, it's in order. So talking about the world economy being more and more open, Canada is a major international destination and source of IP rights, as shown by this graph of inbound and outbound flows of IP applications. It is not surprising that the US is ahead of the game when looking at the preferred destination for Canadian inventors, innovators, inventors, and creators. Next slide, please. And this is for all 3 major IP rights with 61% share of patent filings, 42% share of trademark application, and 25% share of industrial design application. The EU is the second targeted market with respective 10%, 9%, and 18%. China arrived third for patents, 5%, and trademarks 8%, but was out of the podium in 2023 for the application being replaced by the UK with 15%, and China went down by 7%. That's it. Thank you.
Thank you very much. So the federal government of Canada's initiatives are very much mirrored in large parts by the provincial governments across Canada and their agencies, such as Investissement Québec and Quebec Tech, who have the mandate to promote and support the expansion and commercial success of technological startups with high growth potential by offering them visibility and opportunities both locally and internationally. Next slide. Some of the results of these federal and provincial efforts speak for themselves, such as the amount of Canadian direct investment abroad, which consists of the amount of cross-border capital flow in which a Canadian investor has ownership of or significant degree of influence on the management of an enterprise located in another economy. And we can see that by the increasing numbers from year to year in all export jurisdictions and countries as seen on the table. Next slide. These results are also replicated in the revenue generated from merchandise trade with our top 10 trading partners, including the United States, China, Europe, and Asia. Again, slide 15. We have the revenue generated from the trade and services with, again, the United States, Europe, and Asia. So the numbers are increasing, and this is a positive indicator for Canada. However, next slide. Entering foreign markets is full of risks, which consists of many value disruptors. For example, making mistakes, losing investment in the hundreds of thousands, if not millions of dollars, reputational loss, being copied by third parties, once you enter negotiations with foreign manufacturers, distributors, and the like. Not knowing how to adequately protect your intellectual property in foreign markets, there's often the misconception that Canadian IP extends to foreign jurisdictions, which is not necessarily the case. Not knowing how to and when to protect IP, this is something that's essential when we're looking at market analysis, potential letters of commitment or letters of intent to see if there's an interest for Canadian products in foreign jurisdictions. The one type of dicton, as they say in French, but I'll take the expression in English, the straw that broke the camel's back, or as they say in French, la goutte qui fait déborder la vase. And we'll just give you an example of that. Press the video, please. I don't know if there's something in the ether, if it's been frozen or not, but I will continue along with. We'll try again. We'll try again. Thank you.
Oh, hey, look, it's the ice. Why is it so big?
So it doesn't melt. It's actually really interesting how they do it. It's this one company out in Boston that... That went south so fast!
So that basically is a representation of risk that can happen pretty much at any time. Next slide, please. So one of the ways to mitigate this type of risk is to either combo, or in Quebec, what we often refer to as the trio in hockey. You have your IP strategy, your export strategy, and your business strategy. Next slide. So what is exactly your IP strategy? Well, it's not about the knowledge and understanding of the IP rights regime itself, but it includes a strategic perspective where an IP is recognized as a business asset. It is one on which we can generate and regain more value from, and it is also possible to be the source of our competitive advantage. This is something that's extremely important to hold as a message when you're dealing with your intellectual property strategy. It also involves being able to prioritize your IP assets that are core to the business and to make sure that they're working efficiently, that we're able to convert intellectual capital, the ones that are coming from our employees, and knowledge assets into positive financial and economic performance in order to maximize value, which is our value proposition. Then another aspect to IP strategy also is to improve a cross-functional multi-unit communication, top-down, bottom-up, and laterally between different business units, including R&D, marketing, management, so as to avoid any type of IP leakages. Next slide. There's your export strategy, which comprises the steps of conducting market research, identifying target markets, adapting products to market needs, establishing distribution channels, pricing, etc. Next slide. So what is important from this slide is the alignment of business and IP strategy. That you'll be able to effectively use your IP to bolster your unique selling proposition and safeguard your competitive advantage, because what will happen and what happens in any market is that the company is forced to keep its competitors at bay because they all want to have a piece of you. So to illustrate this, we'll take you through a story, a Canadian SME called ABC. ABC, a Canadian company, has a great product and market traction in Canada, but needs to grow. ABC may have a small IP portfolio, it might have a large one, but what that company ABC needs or knows what it has to do is to expand internationally, access foreign markets, for example, the United States, China, the United Arab Emirates, Europe, from an IP perspective to scale and grow. And this is the start of our story that we'll be taking you on today. So I'll give the floor to Damien, that will start the story from Montreal about the company ABC. Thank you.
Bruce, welcome. Thank you for coming. My name is Daniel Calvé. I'm a chemist. I'm a patent agent, a partner, and I've been practicing in IP for almost 20 years now. My role today is to introduce, of course, some basic about IP. Before to leave the floor to my colleagues from our offices in Paris, but we will start with China, then Dubai and Paris. So they will be more talking about what to do when you want to export in these countries. Yeah, this is all. So next slide, please. So basically, what is intellectual property? It's, of course, the works of the mind. It can be inventions, technology inventions, art, books, everything that come from your mind, the spirit of creators and inventors. And IP is protected by law. So you really need to think about this concept that if you don't have your IP protected by law, and of course it provides a monopoly for you to do what once you have your IP rights to do what you want to do with your invention or your creation, but it's a negative right, meaning that it's not, and we see another slide that it's not a commercial right, but it's really to block the competition to use your IP rights without your consent. So it's really the balance. What the IP system worldwide is really to promote innovation, to create, because some of these titles have a limited term of life. So the company need to always improve. And what I say here, that improvements are patentable for patent. I'm more a patent, so I will more focus on patent, but it's the same for other kind of IP. So we have listed different forms of IP, you know quite well: copyright, trademarks, industrial designs, patents, trade secret now is a big part of the IP of your IP assets. Integrated circuit topography for the we see it later. Land breeders' right, and of course geographical indication or appellation of origin. On the next slide, we can present one product. We took something that is quite used today. We have all a telephone like that, but it's a cumulative, so you can have different kind of protection. And so, for instance, for a cell phone, you have, of course, a design of the telephone that can be protected, the screenshot, the logos on the screen, trademarks for the manufacturer, for the product itself, copyrights, and copyright for the software, for instance, the sound, of course, the integrated circuit topography, and of course, we can keep some secret, like the manufacturing process. So, and of course, the patent. So, for one product, you don't think just one protection. You can discuss with your IP specialist and see what type of protection will be useful for your product or your service for commercialization. On the next slide, why IP? I think David already mentioned all this about adding value, of course, to your company. Product recognition by the trademarks, for instance, the brand. In general, having a strong portfolio and being showing to your partners and investors that you care about IP rights, it's very important to attract them and persuade them to invest in your company. Of course, I will see later to access new markets and, of course, new source of revenue. As we say, I will tell later, it's IP rights are something that you can rent, you can buy, and you can sell. So it's property. In the next slide, exactly. It's very important to consider that IP rights are not commercial rights; they are legal rights. And you can take the example for a patented new drug. You can have a patent on your new drug, but you don't have the author because you have a patent that you can commercialize your drug in a country. You have to go through a medical clinic investigation and a lot of work with the health agency of your country, like FDA in the United States or Health Canada in Canada. So make the difference between patenting something or protecting IP rights for a product and have the possibility to market this product. And of course, you have the recurring mistake sometimes is some people are waiting to have their patent or IP rights granted before starting commercialization. This is not a good strategy. You have to consider that there is no good patent, there is just good invention, there is not good trademark, there is just good product. So if nobody wants your product, or nobody gonna copy your product. So it's very a balance between. It's very important that once you have put the protection, you start your protection, you have to verify what is now you have to take care of your commercialization. And proceeding with R&D, developing a new product without considering what is already on the market, what is already protected in the countries that want to do this. Commercialization be a huge, maybe a mistake. Some companies don't want to know, but other, yes. So please consider freedom to operate search before you want to enter a market to be sure that you are not facing issues with other IP rights. And of course, it's as I said before, it's exclusivity and it's a property, so it can be sell rent through licensing, sell by assignment, so and it can be shared like any kind of property. The next slide. So where it's good to remember, I think David talked about it, it's territorial. There is no international patent, there is no international trademark. We see later that you have international application though. Some title, so if you consider going international, you have to consider protection, international protection, at least from the beginning. And some of the titles are, let's say, automatic, like copyrights, famous marks, don't touch them if you can. Geographical indication are now protectable in Canada, mostly from Europe and China. There's some regional indication registered in Canada now for a Canadian product. And trade secrets by the nature are confidential, but patent and industrial design must be granted to be enforced and to be able to use them as a IP rights. In the next slide, it's still so. Before it was not the case with the United States, but now every country has first to file system. So confidentiality comes first. If you start developing a new product, you place yourself in a confidentiality space. You losing your IP right because you as I said on the side, in international and has TPP disclosure could be a problem. So what we call public disclosure, every kind of publication, including internet. I have one client that lost his IP right because he just showed the product before on YouTube. And he didn't tell me, and he never told me that. So the US examiner found the video on YouTube and there was no IP rights to take. So very careful with what you say on internet. Even if you really want to promote your company, time to make the part between what need to be kept secret until you fight for some protections. And remember that sale agreements in the United States are considered like public disclosure. So if you want to really developing your product without considering IP first at the beginning, early stage would be a problem, and maybe you work for the competition because they will. So if your product is a good one or your service is a good one, they will copy. So contact your IP agent. It will be very happy to help you. In the next slides, now we talk about solutions. Some solution, the grace period. So we have some countries, not all of them provide a grace period of 12 months. So the moment you disclose your invention or your design, you can have some protection if you file an application within the first 12 months. But today there are about 12 countries that provide a grace period, like the US, Canada, Mexico, Australia. But if you really think going to Europe or China, there is no provision of grace period in this part of the world, so you will not be able to get a valid IP protection if you discard the invention of the design before you file something in these countries. I have put here a link to the WIPO about the different countries have different rules. So if you're interested to go. So my recommendation today, file first before disclosing publicly. Otherwise, if you have to develop the product with third parties, you need a good contract, you need NDA, you need transfer of IP rights in the contract before you start working with third parties on developing a new product or new services. In the next slide, respect deadlines. That's very, with the patent agent, we always send you reminders about the deadline, but it's very important. In the 19th century, the priority period was created. At that time, it was more because you needed time to go from one country to another. Today, with a click, you can send instruction in other countries to file an application in the next day. But today, the period is like you file the first application in general in your country, and then you have 12 months or 6 months for trademark and design to file abroad to protect the same invention in other countries. You can have some exception, you can have some extension of the priority rights, but be careful. Also, in some countries like France, like in the United States, if the invention is developed on their territory, then you need to file the first application in this country. If you don't, you need to request an authorization to file your first application outside this country. For the Canadian inventors, there is no obligation to file the first application in Canada. In general, we file more like in the US as a professional, or in other countries, or in Canada, but it's not an obligation. In the next slides, we have the title as well. You modify my slide. So we have different international application for trademarks, the Madrid system covering 131 countries, design in Hague system, and the patent, maybe you know more, the PCT system. So with the PCT today, and there is a new country lately, there is 158 countries covered by one application. And the PCT system is a filing system. It's not something, don't consider that you are worldwide protected, your patent pending worldwide when you file a PCT application, but you're not granted yet. And the international phase lasts 2.5 years. So we can, just to conclude on this one, the decision, of course, of granting a patent is national or regional for Europe, for instance, or in Africa. So you will need to consider once there is, so next slide, sorry. Yeah, so here to finish my presentation, there is a two comparison, but they can be combined of the Paris. Paris is just you file from one first application, 12 months to file in other countries. After three countries, we will certainly advise you to go PCT with more than 3 countries. So you see that what is very nice with this tool for the company is that during 2.5 years from the first filing, you can decide where you are going to go. You can decide what you do with your patent, what you do with your product. And you don't have to decide until the end of the international phase at 30 months, in which country you're gonna have your protection granted. And you have also an international search report provided by an examiner before the publication. So you can also take the decision to withdraw your application before the 18 months of publication. That way you can keep secret the information if you don't want this information to be public. If you think that from the written opinion and the research report, you cannot get a patent per se by the document you have. So it's basically everything I want to say today. Just to conclude, the next slide, it's about Garling. So we are very happy to welcome you. So Garling today is an international firm. We have an association with the UK, WAG in the UK since 2016. And we are present in more than 3 continents, 20 offices, and we provide it's a multi-services firm. So for your companies, we can serve you in a different aspect of your development and the commercialization. Next slide. Next slide. And next slide. To finish. So you can see the different offices in the world, and I'm very glad that today we have with us my colleagues from China, from Dubai and from Paris to tell you more about IP and commercialization. Thank you very much for your attention. So I'm asking Thomas to introduce our first speakers from China, Vivian Desmond and Elliot Papageorgiou. Are you online, my friends?
Yes, can you hear us okay?
Yes.
Bonjour, good morning to all.
Hello, hello. So the floor is yours.
Great. Well, we'll be discussing the small company's approach to China from the most common questions that the small companies have. And what's really important in China is not to miss out on a single bite of the cherry. This is the reason that we'll be looking at IP, but also in the greater context of what my colleague Vivian is doing, has been doing for 25 years in China, which is looking at the commercial, the contract aspects, which are at least as important as the IP aspects. So if we can go across now, next slide, please. Right, so very, very briefly, I think that at the moment there's been so much information, misinformation about what's happening in China. We want to give you just on one slide a very quick snapshot because many SMEs and small companies, they listen to all the blagging about what's going on, particularly in relation to some sources in North America. And as Mark Twain would say, rumors of China's demise have been much exaggerated. And then we'll look at points 2, 3, 4, and 5, which are common scenarios that we see. And Vivian will be covering them from the contractual aspect, and I'll be looking at them from the IP aspect. And you will see hopefully how these two aspects interlink. Next slide, please. Right, so in terms of what's been happening in IP in China very, very recently, there's certainly China has been driven and driving towards more consumer-centric and demand-driven economy. We've had this focus on manufacturing for too long, and this is also reflected in where the IP is going. And it's also reflecting where the IP competition is going. So foreign products are still very much in demand, which means the IP around products, brands, etc., is very, very popular and needs to be protected. So if a company is going to China and it's got a strong brand reputation in Canada, that would be the first thing it protects. We'll cover that a little bit more detail in a moment. The local filings have been stable, but because the government has removed subsidies, which is a good thing, we have seen a plateauing of IP rights. We've seen it in relation to patents, where there's been a brief decline post-COVID. Ironically, over COVID, things have been rising. And also in relation to trademarks, where China still has over 7 million new applications. And to give you the context, there were 2.5 million at the EU IPO in 20 years, and China had that by the end of April last year. There's a strong trend, and this comes into a contractual aspect. If Canadian companies are negotiating with Chinese partners, now there's a huge drive to acquire that IP to the Chinese partner, also jointly developed IP. And in relation to what they're doing and what in fact Canadian companies need to be doing is you have to look at both the protection of IP, which means how do I acquire those rights? And that becomes a challenge given the amount of noise on IP rights in China. But more importantly than ever, one should not be too drawn back about enforcing where appropriate. Over to you, Vivian.
Yes, thanks, Elliot. So before we talk about, commercial contracts or IP license agreements, in our experience, we see that for each of the scenarios we're going to talk about later on, that there's always an important step is really to conduct a minimum of due diligence, trying to get information about your potential business partner in China, whether it's a supplier, potential distributor, client, whatever. And another thing is really to make sure that for the agreements, we see that in practice for our Kenyan clients, typically the contracts may be governed by the laws of Quebec, for example, Ontario, Manitoba, whatever. We find in our over 20 years of experience in China, Elliot and myself, that it is useful to actually have a look at the contracts before you actually, run your operations with a Chinese business partner, just to make sure that in case of disputes, the contract you've signed is actually worth something here in China, that it can be enforced after you get, for example, an arbitral award or a judgment in Canada, that it can actually be recognized here in China. and you'd be amazed in practice how many times companies have fell into some traps because they were not well prepared in the early stages of their business relations. So we're happy to help on that. Next slide, please, page suivante.
So very briefly on this, everybody has been talking about the so-called China Manufacturing 2025 initiative. The first misnomer, and this is relevant when you're coming as a Canadian company to negotiate in China, is that it's not China Manufacturing 2025. It's China Manufacturing 2025 to 2049. So all of those have been at glee saying, well, China's never going to meet its goal by 2025, which, by the way, it is on target to actually exceed. It's the goals by 2049 at that anniversary of China that everybody's looking at. And most importantly, though, there are 10 designated priority sectors, which are both a boon if you happen to be in those sectors, because China is going to be inviting your technology and make it very easy for you to transfer the technology in, but also a bane because it means there's going to be a lot of filing and a lot of government support into these sectors. And those of you who will be excused of thinking, well, wait a moment, it covers most manufacturing worldwide. Yes, it does, because China has worked backwards to what it's seen as being developing the first world, and is trying to translate that into a developing and nascent manufacturing sector. All right, so this is China Manufacturing 2025 to 49, the 10 priority sectors. Next slide. So very, very briefly, if you're a company that's coming to a trade fair, and this is the simplest model, you're meeting Chinese partners, you're about to meet them either in China or elsewhere, but especially in China, where many of the world's international trade fairs have now got subsidiaries or locations, you really have to be thinking about, before you even appear, whether you're consumer-centric or business-to-business centric, file a trademark. That's the best 700 Canadian dollars you would have spent, because you're covering 1.4 billion people potentially, and more importantly, you have put a peg in the ground that dates the time from which somebody may have known about you. And if somebody tries to steal your trademark, spending the $700 is nothing compared to the $7,000 to $700,000 you may need to spend to get it back, right? And the other thing that's really quite important, I just saw a typo there, is anything that requires novelty. And this was something that Damien already very helpfully mentioned. There is no grace period in China, which means if you're not supposed to publish it before you file any of the rights in Canada, then go to Damien and his colleagues, file those rights before you go and publish it at a trade fair in China, because there is no grace period. Vivian, over to you.
So another best practice really to adopt. Of course, you have a lot of homework to prepare. Being an exhibitor at a trade fair in China, but in your homework, really, you need to visit the organizers or the trade fair's website, the official website. Naturally, you'll do it in English. Advice by experience also, again, a few weeks ago with the Canton Fair here in Guangzhou, I see that in Chinese language, the original version, there's much more information, as you would expect naturally. So get a good translator, or at least do a Google Translate if you want, but having a translator that knows a bit about China and business practice will really be helpful. Check if there are, for example, in the other exhibitors, some of your competitors, all right, but also maybe some copycats that you have already encountered in the past, maybe about your products or your technology. And then in your preparation work, before coming to the trade fair here in China, prepare a template of NDA, or better yet, what we call here NNN. Here in China practice, it's really necessary to have agreements that go beyond non-disclosure. We want to also include non-use and non-circumvention or even non-solicitation by the Chinese party with which you're going to have some discussions for business transactions in the future. Prepare that in both languages, that would be even better.
And again, if you're thinking, well, am I going to enforce the NDA? It again gives you a timestamp. You've got an NDA signed with your Chinese partner, and as Vivian and I recently advised a colleague's Canadian client, what happens if then that partner to put on the golden handcuffs has filed your rights in China? You're going, oh, wait a moment. How do you prove it's bad faith? Well, if you have a predating NNN or NDA, there's your prima facie proof of that. I've covered the other points, so let's go to the next slide, also for the expediency of time. Right, so now for sourcing. Vivian, over to you.
For this scenario, if you're purchasing products, goods, even services from business partners, suppliers here in China, again, on the due diligence, this is really necessary when you meet people also at trade fairs, very often you'll be surprised to discover after a few months or few years of cooperation that actually your business partner, your supplier is actually not a manufacturing entity, just a trading or an agent. Very often they're very good at even making you visit factories in China that you believe are theirs, and it's actually no, it's a third party supplier. They outsource it, and very often also, and this you will know when visiting more and more factories. I find that when you visit the same factory a few times, you always discover a few things that can be surprising. For example, a factory which is too clean, depending on your business, of course, and the goods. But sometimes when the factory is too clean, that's probably because they don't actually manufacture there and they manufacture somewhere else. That's a kind of example. Due diligence desktop searches with law firms like ours or other consultants, and if possible, due diligence on-site, visiting the factories of your business partners.
Right, and from the IP side,
Elliot?
I was going to say from the IP side, due diligence is very often in China can be as basic as checking that what they claim in relation to what our patents really are patents, because under the Chinese law, a patent can be a utility model, which is like a mini patent of a shorter duration that's not examined. It can be an invention patent, and it can be a design patent, which we would know as registered designs. But more important, what Vivian was pointing to in relation to the agreements, very often you have an IP relevant agreement which gives you non-IP measures. One of the key things is a lot of clients say, well, wait a moment, if we're sourcing or if we're also supplying to China, why would I need to give my distributor a license? Well, you don't give them a license because you're giving them anything. It's what I call the clause 3 factor. The clause 3 of your contract then has all the obligations and all the prohibitions in relation to the license. So you give them a license to use your trademark, and boy, clause 3 has then 15 things they're not allowed to do or they have to disclose to you, etc. So effectively, the license is just a Trojan for you. They feel they're getting a license. A distributor doesn't really need a license in China. But the flip side is they've signed something which acknowledges your rights, perhaps, or hopefully says they will not attack your rights, and more importantly, afterwards has all these restrictions of what they may or may not do in relation to those rights or similar rights. So I think that's pretty key. Vivian?
So in this scenario, this is where you're purchasing products, right, from manufacturers here typically. So the same goes for distributors or manufacturers. What Elliot said about protecting your IP rights, trademark, and if it's, for example, OEM manufacturing contracts, then you want to protect also your designs, technologies as much as you can, and document it. Again, in relation to agreements, the appendixes or annexes of agreements actually do have legal value as well, especially if you get them countersigned by the Chinese party. When you have it, at least if there's a dispute or surprises, you can negotiate, you can fight, you can even go to court here in China. If you haven't signed any written agreement, then it will be very difficult to fight, that's for sure. So in relation to written agreements, need to check, and this may sound very basic, but actually here in China, again, in practice, by experience, so many times foreign companies have fell into traps of signing agreements with companies that are actually established in Hong Kong, and the name in Hong Kong, the name of the company may be exactly the same as another company which is mainland China. If you're not aware of it, actually, by the way, mainland China and Hong Kong are two different jurisdictions, two different legal systems, like you may have also in Canada, a difference between common law and continental law. So Hong Kong works pretty much the same from a legal perspective as in Canada or other common law jurisdictions, whereas in mainland China, it's much more similar to France or some parts of Canada with continental law. Very different rules and different companies, even if the name may sound the same. A typical example, I see agreements that have been chopped. The company stamp is in English and there's the full name. But then how can that be an official chop of a mainland Chinese company? The chops and the company chops or stamps of the Chinese companies here in mainland China are only written in Chinese characters. So if you see the stamp is in English, then it should already raise a red flag for you. Another important point, who is signing the contract with your company in Canada? You need to make sure that the person is duly authorized by what we call the legal representative of companies here in mainland China. if the signatory, even if the person you exchange a lot of emails in English and you have great communication, claims that can sign, you need to ask for a POA or to make sure that it's actually the legal representative of the company. That's public information here in China. We can check it for you. And then in consideration of time, very quickly about other boilerplate clauses, they do have their importance as well. Happy to discuss further, but that goes beyond IP. Elliot, did you want to continue?
Yeah, just on the last point, just because you've checked the IP situation with your Chinese partner, whether you are selling into China and it's your buyer, or whether there's the next point we'll come back to, or you've sourced in China, recheck and recheck. Because one of the things they love is golden handcuffs. After 3 months, after 6 months, after 12 months, double check the position hasn't changed. Next slide. I will cover the next 2 slides in very, very briefly, just to make sure we hit the main points so as to leave sufficient time for our other speakers. In relation to selling into China, again, I mentioned already from the beginning, your trademark strategy is key. And here, the one little thing I want to mention just as a hint is think 4 years ahead. Because you have a 3-year non-use protection for your trademarks, even if you filed it, and it takes you about 6 to 9 months, let's say 12, for the trademark to be granted. So think 4 years ahead. That may be hard, but actually, given how low-cost trademarks are, thinking 4 years ahead definitely makes sense. Another quick point on here is, in China, like everywhere in the world, online selling has absolutely exploded. To do that effectively, whether it's the equivalent of Alibaba, Taobao, Tmall, JD.com, any of these online portals, B2B or B2C, they'll want you to have class 35. In China, that's the equivalent of what we have internationally as retail services. And those portals want you to have that, even if you're selling class 9 product, class 25 clothing products. The reason they want you to have class 35 as the big hint is because it protects them. Because class 35 is promotional activities for third parties. You are the third party, but they want to be protected. Okay. Now, the very, very brief point on here, and I'll let Vivian go back to the import requirements, is to also consider whether, in fact, selling into China involves any technology transfer. And this is something that's worthwhile doing a quick check on. Vivian, to your points on this.
Very quickly about import requirements. Well, in China, it works also pretty much the same as other jurisdictions or European Union. Of course, standards may be different from what you have in Canada or North America. Another point where I fully agree also with what Elliot said about thinking 4 years ahead from a commercial perspective in China, it also makes a lot of sense to put, for example, performance targets, sales targets per year, so that it would allow you to exit the agreement with a distributor if the performance did not meet your expectations.
Just briefly, next slide. Just one point on the next slide, I think that makes sense, because this is something Damien mentioned as being an important right. And as in the EU and in Canada, we now really have a situation where most lost IP rights, and Damien foreshadowed this, relate to trade secrets. And the key thing in China, like you may be familiar from the EU, is you must have a trade secret protection policy and you must implement it. So in other words, you have to show that you've treated it as secret, which means you don't have pooled printers, which means it's not available to everybody, and actually that particular employee falls, or that particular entity falls within that obligation. So this is key. Once you've got that in place, you can think about protecting trade secrets. That's my only point on this. Vivian, over to you to perhaps close on this.
Point about labor law here in China related to IP. When there are technical improvements, this is also a big topic here in Chinese law and practice. Technical improvements by your supplier, distributor, and by the employees. Actually, Chinese law, which is a continental law system again, Chinese law would provide a lot of rights for the inventors here in mainland China. Even if the background IP is owned by you, there are Chinese rules that need to be considered. So happy to also advise on that. Elliot, did you want to finish the slide or go to the next one?
Yeah, to the next slide. And Damien is going to make these slides available to you. This is just a summary slide. If you go to the next slide, the takeaway points, really, we're not going to cover them, just for Damien to show it to you. And then the very last slide, which has got a 1-sentence story to it. Next slide, please. Again, there should be a picture on it, right? So if you're looking at this particular picture, I think it epitomizes China wonderfully. Many people look at this and go like, wow, look how well behaved these dogs are. This is actually not a photo montage. It predates AI. This is a picture of a German police dog training school. And the picture within the picture and the secret within the secret is just like with China. Here, the so-called Top Gun are not the dogs. The handlers are off picture, but for every 7 generations of dogs, only 2 generations of cat go through. So the cat is really the Top Gun, and the dogs are there to be trained. And this is one of the great tests on whether they can resist the temptation. Hopefully, you will be prepared for China and can resist the temptation to jump in. Thank you.
Thank you. Okay. Thank you, Elliot and Vivian, very much. We know that it's quite late in China. It's already tonight. Thank you very much. You will stay online? Wait, some questions? Okay. So now I'm going to introduce you. The next speaker is, she is Tamara, Madame Tamara El-Shibib. Tamara is a principal associate based in your Going WZ Dubai office. And she's specialized in patent law, IP strategy, and technology transfer. So, and she has, Tamara, are you there?
I am here. Can you hear me, Damien?
Yes. Hello and welcome to Montreal.
Thank you. Very happy to be here.
So we're listening, waiting for your first slide to appear on the screen.
Sure.
Okay, voilà.
Perfect. So just in the interest of time, I'm going to just sort of dive in and try to pick up and maybe skim over some of the things that are more introductory. So I was planning on covering, thank you, covering sort of the background of the GCC region. I think most people know here the GCC is an alliance of 6 countries in the GCC in the Persian Gulf. The population size is around 55 million. Basically, almost half of the world's oil reserves combined are from the GCC countries together. Recognizing this, but also recognizing that those reserves are going to deplete eventually. These countries are all looking at diversifying away from dependency on oil and gas and investing more in other non-energy sectors like tourism, construction, finance, and also in innovation. They're very sort of attractive markets for most. I think it's mostly because they have very business-friendly environments, sort of low tax and no income tax. And I'll get into that in a bit more detail in the coming slides. Next slide, please. So the GCC is very different to China and I guess the other jurisdictions you'll hear about. It's civil law jurisdictions, mostly in all the GCC countries. There's a bit of influence of Sharia law, particularly in Saudi. So that means when it comes to claiming damages, you actually have to show actual damage caused. There's no such thing as loss of profits that you can recover or anything like that in Saudi. UAE is different, you can. Arabic is the official language, but they all have very high expat population, so English is widespread. There are some political, cultural sensitivities here. So for example, cannabis products are illegal. If you're looking at doing any IP registrations around cannabis or gambling, for example, those will likely get rejected by the IP offices. There's a different work week for all the GCC countries except for the UAE. So the UAE is Monday to Friday, everywhere else is Sunday to Thursday. That's important because if you have any filing deadlines, you need to make sure they get in before the Friday. Deadlines don't roll over to the next working day in these countries. The other thing is, well, being civil law jurisdictions, there's no system of binding precedent except for the top courts. So the Supreme Court or the Court of Cassation, those decisions are published and they're binding. Any other sort of court of first instance or court of appeal decisions, they're not made public. So it can be tricky to navigate because you can't look at case law and see what's happened. You have to have experience on the ground. Next slide, please. So I'll focus a little bit on the UAE. I won't spend too much time on the slide. I think most people are familiar with the UAE. It's basically a federation of 7 emirates. Dubai is the more sort of famous emirate. It's a tourism hub, it's a trade hub, but Abu Dhabi is actually the capital. We have the top 10 shipping port in the world based in Dubai. That's Jebel Ali. As there's lots of goods coming in and out. We also have one of the busiest airports in the world, and there's sort of 2 more being developed as well. They've also established these areas called economic free zones across the UAE. And I'll go into a bit more detail in the next slide, please. So basically, as you can see in that little map, the free zones are sort of economic areas that are spread across the UAE. And the benefits of the free zones is you can have 100% foreign ownership. The mainland laws don't apply. Some of the free zones even have their own laws. They've sort of set it up so that it's easy for companies to come in, to sort of set up their businesses, to hire people, to get their visas done. It's much more seamless than sort of operating onshore. They're also catering to specific industries as well. So you have, for example, the Media City Free Zone, where you'll have the big networks based there, and they're all foreign owned 100%. You also have Healthcare City. And so they've set up these economic free zones around specific areas. And there's a lot of, I guess, activity going on within those free zones. Next slide, please. There's other incentives if you're not based in the free zones as well. So I'll talk a little bit about the options for setting up in the UAE, but just generally in the UAE, the other sort of initiatives that they've been working on to try to make it more attractive for people to come here. One of them is sort of the Golden Visa. I'm sure a lot of people have heard of that. It's basically a long-term residence visa for entrepreneurs, investors, property investors. They've also included the category for inventors as well. So if you're filing patents here and they're granted, you could technically use that to apply for a golden visa and make the UAE your home for 10 years. There's 0% tax on personal income. I think a lot of people are very surprised to hear that. There's the exchange rate is stable, it's pegged to the USD. Yeah, and basically those are the benefits. Next slide, please. So when you're looking to establish in the UAE, there are some different options you could look at. Initially, if you were establishing a branch in the UAE, you needed a local agent. What that basically meant was you needed a partner that was an Emirati, a national, or an Emirati business, and they would have 51% ownership of the company, and you would have 49%. They'd be a silent partner, but you had to have a local partner. They moved away from that a little bit. It still exists. But now, in the last 5 years, they've allowed for complete 100% foreign ownership in most areas. There are some areas of commerce where you can't have foreign ownership. That's banking, insurance, I think defense. But now you can come into the UAE and set up 100% foreign-owned company, and that can be onshore. When we say onshore, we mean not in the free zones. You can also set up in the free zones, of course. I kind of covered the benefits for that. The only thing to keep in mind is if you're setting up in the free zones, you can't trade directly in the UAE. So you would need to have a local partner or go through a local agent or have a branch to be able to trade in the UAE. Next slide, please. So if you're going through a local agent, there are some things to keep in mind. Your agent, you could register the agency, or you could have it as unregistered. If you register it, you need to be careful because there is a commercial agency law that is very much in favor of the registered agent. So the registered agent would have exclusivity over the UAE market to distribute your goods. But the law is very protective of the registered agent. So it's not possible for you to sort of cut that agreement. Even if you have a defined term, you have to have a justifiable cause to end that. You also have to specify what are the products. So you wouldn't want to be just sort of licensing your trademark without specifying what products it should apply to, because that might give them room to claim everything under the brand, basically, that you decide to enter the UAE market with. Same thing with franchisees. So basically the message here is if you're looking to go through an agent or you're putting in a franchise agreement in place, you definitely need to speak to an IP lawyer on the ground. They can help you prepare an agreement that will protect you. Next slide, please. So in terms of areas of strategic importance, they're quite broadly defined in the UAE. Food security is one of them. 90% of the food is imported here. Waste and water management. These are basically the areas where the government is investing a lot in. So if you're innovating, or if you're a company that is innovating or bringing sort of new product services in these areas to the UAE, you'll likely find a lot of support. There are a lot of incentives for companies in these areas to come, access to grants. There's spaces that have been developed so you can get access to working space and other initiatives that other benefits that they've introduced to support companies in those areas coming through. Next slide, please. Canada, UAE have a great relationship. I think the UAE was Canada's second most important or biggest merchandise trade partner in the MENA region in 2021, following Saudi. Trade between the two countries was at 2.5 billion in 2021. That's gone up to 3 billion in the last year. And UAE's foreign direct investment into Canada was around 1.3 billion in 2021. That's also gone up. The little image that you see there is DP World. So DP World is a UAE-based logistics company, and they've entered into a partnership with a Canadian pension fund out of Quebec. And together they're basically building up, expanding core operations across Canada. And I think that was they recently invested around 4 billion together in 5 cities across Canada. And so yeah, there's a lot of collaboration and opportunities there. Next slide, please. In terms of IP protection, thing to know is all the 6 GCC countries are members of the Paris Convention, TRIPS, Berne, PCT. There's a typo there, it says Madrid too. I would put in brackets, Saudi is not yet. Saudi is in talks to accede to Madrid, but they're not there yet. So if you have a patent application that's filed or a PCT that's filed, you could click national phase in all 6 GCC countries and get your patent protection that way. You could also file, of course, directly. You would need to appoint a local agent in each of these countries. I think one thing that sort of scares people away from the region in terms of IP filings is the formality requirements. I think they've simplified that. The message here is basically they're trying to simplify and improve the IP registration and enforcement systems to make it more friendly to innovative companies. One more thing here on the slide about grace periods, I would say that the UAE has a grace period. So if you have published, you're still okay if it's within 12 months. But the other 5 GCC countries are absolute novelties. So you cannot disclose, you cannot publish before filing. So keep that in mind. Next slide, please. I won't spend too much time on this, but basically this is sort of the recent developments. I put UAE and Saudi because there seems to be a bit of a race between them in terms of who can improve and strengthen their IP systems and make them more aligned with international systems to attract or I guess establish themselves as innovation hubs. Some of the things they've introduced in the UAE is like expedited examination, so you can get your patents granted in as little as 2 years now. Traditionally, patents could take 5, 8 years. Some have even been longer to grant. That's all changed in the last 5 years. And something else that's very recent as well is that they've started publishing pending patent applications, which wasn't the case before. So now you can see who's filing in the UAE. With Saudi, they have PPH agreements, which basically is a way to expedite your patent applications in Saudi. If you filed in China, if you filed in the US, you can get them sort of expedited and granted much faster through the PPH route. And Saudi is the same. They've really sort of beefed up their examination capabilities, and they're also granting patents in as little as 2 years. Next slide, please. In terms of challenges, these countries are still catching up. So their IP is still sort of a developing area of law. They're improving their systems in terms of registration, but when it comes to enforcement, it's still quite low. As I said before, there's no published case law or system of precedent, so it's difficult to advise or predict on outcomes unless you're a party to a dispute. That's the only way you have knowledge of sort of how the courts might handle something. Registered rights are key for enforcement actions, so you have to have a registered IP right here. You cannot rely on patents of origin. Your licenses have to be recorded as well, or any interests in IP need to be recorded with the IP offices for infringement actions. It's possible to record your IP with customs. That's available in 5 Emirates, Dubai, Dubai, Abu Dhabi, a few a few of those, but basically only trademarks can be recorded at customs and you have to notify them. Yeah, next slide, please. So I think I'm almost at the last one. So grey goods. Grey goods is a big problem, I think, in the UAE. The UAE is a hotspot for them. We have a high expat population. So people are always looking for products that can come in cheaper, faster. And authorities don't really stop them because as long as they're genuine products, they don't see why they should. And the laws in the region as well, including the UAE, they don't really allow brand owners to prevent importation and distribution of grey goods as well. And so that applies to a lot of different products, whether it's iPhones, cars. You'll see a lot of grey good products entering the UAE. There are ways to sort of tackle that, but again, you would need to speak to a trademark lawyer and see how you could maybe work on labeling the products in a different way and sort of bringing that to customs authorities. Next slide, please. Okay, so this is the last line. I would just basically say if you're a company coming into the UAE, let's say you have a patented technology, maybe first thing you want to do is get your trademark in, make sure that it's not being used, do a search, register it. 3D trademarks are actually more easier to enforce than design rights in the UAE. So we're seeing that being advised as sort of another form of protection that you can sort of get enforced much more easily. Like I said, PCT is available if you're looking at extending your patent protection. You can also expedite your patents, get them granted faster because you need granted patents to be able to enforce. If you're going through a partner, make sure you work with an IP attorney to carefully draft your agreements. If the GCC is a big market for you, then maybe consider just establishing directly. Next slide. Oh, and that's that. I'm happy to take any questions if there are any.
Thank you very much. Sorry. At the end, it was very interesting. And you stay with us for the questions?
Yes, I'll be right.
Thank you very much. So our next speaker, she's from France, like me. So Céline Day, she's a lawyer in Paris and co-managing partner of our office in Paris and UPC representative. Céline is an expert in IP and information technology with over 20 years of experience. So Céline, are you with us?
Yes, I'm here. Can you hear me well?
Yes, Céline, merci beaucoup d'être avec nous.
Avec plaisir. Merci beaucoup. Hi, everyone. So I'm going to talk about IP in France, but more generally IP in Europe. So I wanted to show you a first slide to just introduce you the general legal background that we have in Europe. Some of you may know that Europe is a combination, I would say, of national legislation and European legislation. So IP is a quite well harmonized area of law in Europe. I've put some example of directive regulation that we have in IP. It's not exhaustive. We have IP enforcement directive, directive on jurisdiction, directive on trademark rights. We have the European Union trademark. We have the European Union design. We have regulation on data protection. We have the brand new Unified Patent Court agreements and also unitary patent. We also have a directive on trade secret that's not mentioned there. So it's really, IP is really quite well harmonized area of law. But when we say harmonized, we need to be cautious because there still remain some differences between the countries. So there is an harmonization on big principle of protection and enforcement of IP rights, but there are still some specificities, national specificities, because either the directive authorized the member states to implement, to have a room and some freedom to implement, or because we still have some specificities in procedural rules, for example. So the key takeaway here is that Europe is not a single market for IP. It is well harmonized, but when you want to enter a market, be cautious and still check the specificities of this market. And we will see in the coming slides some example of that. So we're going to see together first how to protect your IP right in Europe, and then some slide on enforcement. So protection of IP rights. This slide shows, like I said in the introduction, that always two levels of protection, national level. So you can file these examples for trademark, patent, design. You can file on the national level if you want to have a national protection. So you go before the national offices to get a trademark in France, in Spain, in the UK. If you want to get a broader protection, you can file before the European office. So we have the European Union trademark, that if you can obtain such trademark, you will have a protection covering at once the 27 member states of the European Union. That's a great protection, but that's also a difficult protection to get because, of course, you will multiply the risk of having prior rights in the number of countries. So, but if you can't obtain your European trademark, you can still convert your filing into national filings where there is no prior rights. So basically, you will file depending on the markets you want to operate. If you want to enter only one market, two markets, you can limit your filings to national territories. But of course, having a European trademark, it's broader, and it's always a good protection. So always try to get a European trademark. It's a good thing. Second key message here is that Europe does not recognize use. That means that if you use a sign on a territory, you will not get any protection. So really, before entering a market, you should really first conduct prior right search, very important. And second, file a trademark. On the patent side, it's the same. So we have so either national protection, we said, or European patent protection. And here we have two possibilities. Either you go for the classical European patent that you can validate into 39 countries, or brand new, since one year and a half now, we have the unitary patent. So like the European Union trademark, you can have one patent covering 18 member states. So today, only 18 member states have ratified the unitary patent, but hopefully soon we hope that will be the 25 countries that can be covered by this unitary patent. We can go to the next slide, please. So some consideration on costs. So you see for sure that filing cost depends on the territory. If you file national, it will be less costly than if you file European. What's interesting here is that we've done comparison between the European patent and the unitary patent. So again, and like for trademarks, but it's more relevant than in trademarks due to the cost of a patent. So you can see that these are the annuities. So you have to pay the fees you have to pay during the life of a patent. So basically, if you want to, if you are interested in protecting your invention only in 3 countries or less than 3 countries, we would recommend you to go for the classical European patent. And if you want to be protected in more than 5 countries, you should go for the unitary patent. In terms of cost, we can see that it is, of course, much more relevant. If you would be filing in 18 countries, you can see at the very last line the huge cost And so you can see that the economy that you can make with the unitary patent, it was really made for this. Just before going to the next slide, just important mention here, as you know, the UK is no longer part of the European Union, so you cannot protect your invention in the UK with a unitary patent. So if you want to protect your invention in this territory, you will have to file a separate patent there. Next slide, please. So this is just to illustrate the scope of protection of the unitary patents. And you have in light blue, yes, the member states that are not yet into the system, but that hopefully will join soon. We can go to the next slide. And so on the next slide, I wanted to draw your attention on some issue. I would say that hearing my colleagues talking about Canada and Dubai and China, I just want to highlight some interesting points, and that also highlight the differences with Canada and the differences within the member states within Europe. So, for example, on employees' invention, basically the rule for ownership is the same. It is that the invention belongs to the company if it has been made by an employee, but you have different conditions that will apply in Germany. For example, there's no condition. In France, in Spain, you will have to have a very specific clause, mission clause in the agreement. In other countries, it will be other considerations. So in this regard, le diable est dans les détails, comme on dit en français. So do not think that an invention that has been created by your employees automatically belongs to the company. There are some check-ins to be made here. Compensation also. Compensation is a big topic for invention. In Germany and in France, compensation to the employee is mandatory. So if you don't compensate the employee, it's a breach, and you can the dispute, and it can cost a lot to the company. In Spain, for example, there is no compensation to be provided to the employees. On copyright, some key points on copyright. So copyright is a work is protected by copyright provided it's original. There is no registration required for copyright. And for copyright, contrary to invention, they belong to the author. So no ownership for the company automatically. So for copyright, it's very broad, as Damien said. It can be the website, it can be your logo, it can be any design, it can be the shape of your product. So for that, you really have to provide to draft an assignment contract and to have so assignment of rights from the employee, assignment of rights from the supplier, from the providers. So that's very important. And the only exception is software. So software is protected by copyright, but under European law, it belongs to the company as long as it has been created by an employee. So that's an important exception. On moral rights, so we've seen that Canada has aligned legislation on not moral rights, but on how do you call them, on commercial rights, but on the moral rights for copyright. In Europe, it's and in France in particular, it's perpetual, and it can't be waived. So you will always have to deal, even if you have been assigned, even if you are not in the period of protection anymore, you will always have to deal with the moral right of the author. Another interesting and maybe difference in Europe is the unregistered European design. So contrary to a trademark, you can't have unregistered trademark. unless very well-known trademark, but this very specific case. You can have an unregistered design in Europe. This is for a period of 3 years, but this is very specific. Usually it is used in the fashion area. So in areas where products are quite seasonal. Another attention point is trade secret. We've spoken about trade secret before. It's very important when you, of course, are an innovative company. So trade secret, I said we have a European directive. So more or less, we have the same protection over Europe. It was already protected under French law, for example, but I echo what Elliot said before, is that, like everywhere, I guess, the main issue with trade secret is really to be able to identify the trade secret, to be able to show that you have kept it secret and confidential. So it is very much all about contracts, all about putting a lot of confidential on your documentation, and all about identifying your trade secret when you enter an agreement with a partner, in order to be able, really, when you have to enforce before a court, to be able to prove what it is about and that you have protected it. Once you have this, the court system is really good, the law is really good, and you can really enforce your right on your trade secret. We can go to the next slide. So enforcing your rights. So on the next 2 slides, you will see, and you will recognize the slides regarding to filing. It's the same. We have this combination of national system and European system. So if you want to enforce national trademark or European trademark when you are in infringement action, for example, so you have your trademark filed and registered, and you have a competitor that is using your trademarks or similar trademarks, so you have to go before the national court. But you have some exceptions. So for instance, when you want to file a cancellation action against a European trademark, you have to go before the European office. And then you have to follow when you appeal the European Board of Appeal. Then there is the jurisdiction of the General Court. And then there is at the very top, the jurisdiction of the European Court of Justice. If we go to the next slide, the same for patents. So if you enforce a national patent, you will enforce it before a national court. If you are to enforce a European patent, you have 2 different possibilities. Either you have opted out your patent from the brand new Unified Patent Court, so then you will only be able to go, or a claimant and competitor will not be able to sue you before the Unified Patent Court, and you will be before the national court. If you have not opted out your patents from the Unified Patent Court, then you can be sued, or you can sue and enforce your rights before either national courts or before the Unified Patent Court. If you have a unitary patent, so these brand new patents, you are obliged, and there is only one jurisdiction, and you go before this brand new Unified Patent Court, which is a very efficient patent court. So it covers the 18 member states I talked about before, and it is so it is one decision, and you cover 18 member states at once. So it's a very efficient new court that we have, and before which, as Damien said before, we are, as French IP and patent litigator, able to represent client before. We can go to the next slide, and I'll be finished. So just a slide, and the next one are on the capabilities of the Paris office. So we cover everything that I've discussed and more, as you can see in the slide that I'm sure that you'll be given at the end of the seminar. Thank you.
Thank you very much, Maître Beth, for the very insightful conversation on European law and IP. I'll invite my colleague from the Trade Commissioner Service, Frédéric Papillon, to join me at the podium, because the main question that now comes for entrepreneurs is, how do we export? How do we pay for it? What kind of programs are available to us? And Frédéric will be more than happy to enlighten us on that. Thank you.
Yes. Thank you very much, Maureen, and I just want to say it's a privilege to follow such passionate IP experts. We have a very great Q&A session planned in a few minutes. I promise not to take up too much of your time while I will deliver key messages. So my name is Frédéric Papillon. I'm a Trade Commissioner with the Trade Commissioner Service. My colleague Eric provided information about what the Trade Commissioner Service is. Allow me to tell you what the Trade Commissioner Service does. I work at the Quebec City Satellite Office, paired with the Montreal Regional Office, and we work directly with companies. Our role, thank you very much for joining this line. Our role is to provide personalized and tailored advisory services to companies so that they can export more effectively. By gaining market insights, connecting with key contacts, we help you find new opportunities, and all that added intelligence and business information is aimed at making sure that companies reduce the risk of exporting or doing business overseas, and also avoid costly mistakes. Can you please change the slides? So this is the Trade Commissioner Service in general. Our role, particularly at the regional office, is to basically be the first point of contact for Canadian companies. We take the time to know who they are, what their needs are, and then we tailor our service offer to meet those needs. So we can go to the next slide, please. So who do we work with? Of course, Canada has a lot of companies. We work with companies of all sizes. We work with companies in all sectors. There's a little but. We work with companies that have already conducted their market research and have a business plan for international activities. So basically, our value added is essentially with the market validation and also finding key contacts. So the market research part, we leave that to other institutions such as the regional expert development agencies in Quebec called the OPEX, to just work with the companies to accompany them for that. So while advising companies, there are a slew of programs from our partners at the federal levels and also at the provincial level that can help SMEs better export. I would like to point out to one key one from the National Research Council of Canada, the Industrial Research Assistance Program, NRCIRA. I know like the government will say a lot of acronyms, so I'll spell it out once and use the acronyms after. The program IP Assist, that's one of the best programs out there for companies to use. It will pair the companies with the help of experts to understand what is your IP portfolio, what is the value of it, and also what you should file and maybe what to file at a later time. Given the cost of filings and also the complications in different markets, it's probably not best to file everything all at once, but the experts at IP Assist will help companies decide what is their highest value assets and what they should prioritize filing first. And the third role is also Elevate IP that will provide funding to business accelerators and incubators across Canada to help raise awareness on IP and also incentivize companies to develop their own IP strategy. In Quebec, it is delivered by the Mouvement des Accélérateurs et Incubateurs du Québec. The program is branded as Momentum IP. And so this is the Quebec branch for delivering those IP services. There is also help with IP costs. So for example, at the provincial level, you have Investissement Québec that offers the innovation program. So given the projects, the scope of the projects, where they go, some filing costs for IP can be covered for domestic filing, of course. For global affairs, we have a program called CanExport.
probably heard of it. And this is the one we have available, that we make available for companies to help them now with IP costs. Since 2022, we do add those IP eligible expenses into CanExport projects. So if you heard of CanExport, just want to basically give additional information that there are two main streams CanExports available to SMEs. The first one being CanExport SME, aptly named. It helps companies to basically cover travel costs to expand into new markets. So markets where they have no presence or where they would like to establish a presence, we cover travel expenses for exhibition at trade shows, and now as well IP-related costs. So searching databases and filing overseas. The other stream is CanExport Innovation. This is aimed at securing and also formalizing an IP partnership with a foreign partner. So under that stream, we will cover travel costs, meeting costs with the experts, all that with the aim of formalizing the research partnership, and of course, the IP-related costs will also be covered. We can move to the next slide, please. So again, these are the differences between CanExport Innovation and CanExport SME, the scope of the project. For CanExport SME, all companies are welcome to apply. At minimum, 100K of revenues annually, up to 100 million. Past that mark, the company is no longer an SME and can basically look for other advisory services. And CanExport Innovation is a bit more lenient. It's more about formalizing the R&D partnership. We can move to the next slide, please. So connecting with us is the best way to get started. Connecting with us at the regional level. As said, our role at the regional office is to be the first point of contact for Canadian companies before they export overseas. What I would like to give you, to convey with you, is think of the officers like me in the regional office as a family physician for companies. We work with them as long as they need. We accompany them along their way for their international market expansions. And when there's a need for particular information about a market, well, we refer them to our specialists in all of our Canadian consulate and embassies overseas, and sometimes at headquarters, such as with my colleague Eric. So this is the first point of contact we do. We work with clients as long as they need and require our services. And also the next slide, please. We have the contact information for some of our colleagues overseas. Of course, there's about 1,000 trade commissioners overseas, so you can fit them all in a slide. We do have the usual suspects, as I like to call them. There are trade commissioners in the US, China, Japan, France, United Kingdom, and Mexico. But other countries are as important as well. So given, in four or five more slides, we could add all their names in there. So closing, just before wrapping up to the question, Statistics Canada ran an interesting study back in 2022 about innovation in Canada. And there are three common denominators for Canadian companies that are very successful in the nation. One, they participate in international trade. So companies that trade overseas, they are more innovative than others. The second common denominator is they work with government agencies. Provincial, federal, municipal level, they all work with them. Third common denominator, they file for IP. So my message to companies is leverage government institutions. All of us, federal, provincial, municipal, we work together. We offer a complementary service offer, and we also complement each other. If we're doing a good job, we will tell us, yeah, good job. Thanks for helping this client. This client has succeeded overseas. So everybody that participated is worth their recognition. And also, second message to companies, file for IP. Protect what you have. It is valuable. And if you're just starting, you don't have an IP strategy yet, there's a lot of possibilities, at least have the IP talk. There is help for you with all the governments and also all the professionals here. So don't hesitate to get started with protecting your IP. So I thank you very much. We will have questions in a few minutes. Thank you very much. And don't hesitate to reach out for information. Thank you very much, Frédéric. So I'll ask the panelists to come up onto the main stage. Or And we'll open up the floor now for any questions that participants may have both online and in person. So feel free to ask me. The floor is open. Like I said earlier, this is a very unique opportunity to have this much expertise globally, internationally around the table with us today. So I do invite you to ask your questions. I don't know if there are any online or. So that's what it is.
Something I began to see on the internet is what they call, and you heard it once here today, it's a 3D design. Because people print on 3D printers. And somehow on the internet, the discourse is different from wherever we look at. And so sometimes they consider that we can protect under copyright a shape. So I don't know if you can add about that. And just a second question, when we get an IP official like patent, whatever, those who began to use it because it was patent pending and we began to exploit a disclosure, what happened to those who already have their own unit, or can they continue to use it? Can they continue to resell it? Or that's the kind of question.
Thank you very much. I see that you soaked in a lot of the information today because these are the hot topics of IP law today. When you're looking at questions of 3D printing, you're not only just looking at the issue of copyright, you're looking at the issue of the trademark, the trade dress. You're also looking at the issue as well as to patents behind it as well. So I don't know. I leave the floor open to some of my colleagues internationally. How has 3D printing been dealt with in your jurisdictions? All the microphone seems to be muted or.
I can go first, maybe. I have no example of. So you're talking about design, or you're talking about maybe filing 3D trademark, because we can also have 3D trademark filings.
Personally, I think for the final result, you can always protect by a design application. Someone spoke about 3D remarks. So of course it's another way maybe to protect the resulting product. But it's like creating, so it's with the copyright as well. So it has to be depending what you want to do with the final product you are with the printing. I don't know if it was on our consideration, but the fact that I think that the fact that the product is made by one 3D printing or maybe an artist that will create the final object doesn't change that final object, how the final object will be protected. Is that object at a function? If yes, maybe there is a patent for protecting the final. That doesn't really rely to relate to how it was made for the 3D printing. For your second question, once your patent pending, you have some rights, and the publication is very important. So if there is no, that's all for patents, if there is no major difference between the claims that was filed at the beginning, the claims are the small sentences at the end of the patent that define the protection. So if when the patent is issued, then you can go in court. If you have an infringer in the country, the patent is in force. If the judge, if there is infringement, there is some liability on if any selling was done from the moment the application was published. You can have some compensation for the selling of the infringer the product infringing your IP rights. I think it depends on the countries, maybe.
It also depends on the countries, but I was also going to add the way that I would look at it initially when you have the initial product that you're trying to build or design. You have to look at it from a due diligence risk perspective at the very beginning, meaning that once you do your due diligence, you're looking at your landscaping or your IP landscaping to see what already exists on the market or not, to know, am I in a position of infringement? Yes, no. If I'm not in a position of infringement, or if my risk level is relatively low, then at that point you start exploring what are the different forms of protection that I could use in order to get the best protection or optimized protection on that particular technology. Does that answer your question, Park? Okay. We can obviously speak, of course, afterwards if it has to go more depth.
Just to add, so my last slide, I show you the timeline of the PCT. By general, an application is patent application is kept confidential for 18 months. So even though you do a search, maybe during the time you're doing the search, there is no publication, but it's a fast filing system. So it's not because it's not published that it does not exist, but the moment the application is published, even if you don't spend your time looking in the databases of the IP or patent offices, it's published. So you have to, as a company, you have to do your work to search for this kind of publication before starting your project. Because you cannot say, oh, I didn't see the publication. Yeah, but the publication is there. So for the patentability, it's international, and the language doesn't. I mean, today we can translate the examiners. They will have access to all the Chinese or international application and have the translation made by the computers, the AI. So there is no possibility to do it. So it's important to do your work on FTO or patentability search first. Yeah. We have a question online.
We have the question and answer section. Question from Ashley Appeal. What are some best practices for ensuring IP protection during the early stages of research and development, when collaborating with international partners or institutions, especially in a collaborative environment where transparency is required, but safeguarding IP is critical?
So best practices. Recently, the Government of Canada has published its research security guidelines. So right there is probably step number one, is to be able to know, are we transacting with the right parties internationally? There's a lot of what I call KYB or KYC, know your client, know your technology, know the bodies with whom you're dealing with. There's a lot of named research organization lists that are available by CSIS as well as by ICET that you have to be able to verify to know if the bodies are allowed to be transacted with. There's also the issue of economic sanctions that are going on currently as well. Those are other lists that one has to be aware of, again, to know, are we allowed to transact with these research entities? It'd be surprising as to how many of them actually appear on the list globally, since this is a problem that has become of national concern in Canada with economic security as well. So that would be the first part of the best practice.
We have Elliot who wants to contribute.
Oh.
Elliot as well.
Yeah, I think there's two things in relation to China you have to be aware of, and the best practice there again is to do your homework. But specifically, as far as the research practices, you may be thinking that you're dealing with a research organization or dealing with a university, but what you have is you have an overlay of different policies. So the university may have policies as to IP ownership. Then you will find that the city, for example, Shanghai, has its own policies as to IP ownership. And then beyond that, of course, you've got the national one. So you actually have to dig through all of those to make sure that you know which policies apply and in relation to which research. And then the other hint or the other sort of best practice to look out for in China is to, again, it comes to know your partner, but that aspect derives from the fact that with a number of the now prohibited practices, you're looking at, for example, chip manufacturing technology, you're looking at AI, you're looking at quantum computing, etc. What a lot of the big Chinese companies have done is they have basically farmed out their entire department. So from one week to the next, Huawei may not have certain departments within its body, but the same staff are now working with the university. If you're collaborating with that university, effectively what you're doing is you're collaborating with Huawei, which you may be unaware of. Now, there's pros and cons to each, but again, the best practice is to know who you're dealing with so that later on, let's say you've got a grant from a government in the EU, this is an issue. If the EU has finance, for example, a company like IQM Quantum Computing, which is Finnish and EU financed, they have certain restrictions as to how they can collaborate with certain countries and certain entities within those countries. So again, dig down, make sure if you're collaborating with somebody, it really is that institution and that you're comfortable that that institution will not later on, I guess, that relationship will not later on trip you up when you're looking at the next round of financing or the next round of collaboration or exploiting the results of the collaboration.
Can I just add something onto what Elliot said? Basically, it's quite general, I think, when you're looking at early stage R&D and you have multiple collaborators, to maybe think about sort of what is each party bringing into the collaboration and defining the background IP very clearly. So I used to work in tech transfer, and some of the issues that we came across a lot was, you know, access to background IP if you need it to commercialize the foreground IP. You know, have those discussions up front. Also make sure you get IP assignments in place. If you have researchers from different entities, they come and go. If you have high turnover, especially with our markets, people are in and out all the time. You need to make sure you have IP assignments in place so that you can actually move forward with the IP. Also, like Elliot said, if there's any funders of the research, they might have potential claims, so make sure that's all ironed out up front. And then just sort of define between the parties who's going to be responsible for managing the IP, how, you know, IP expenses will be handled, who's going to make decisions on commercialization, ownership, you know, agree on these things up front. It's a lot harder to put those terms in place later. So as much as possible, I think just agree on what you're looking to achieve from the collaboration and make sure those are in line, your positions in terms of IP ownership and access are in line with any institutional policies or national policies in place.
Thank you for your presentation. My name is Ellen Moore, and I'm a life science consultant. Basically, I help my clients to sign licensing deals, biotech, medtech. One topic that hasn't been really talked about today is generative AI. Now I have more and more customers that own IP related to that. Of course, I'm a little bit puzzled. I try to educate myself. I'm a biochemist. I'm not an engineer, software engineer. And I try to really help my customers to protect their IP. So I'll give you like an extreme example. Maybe Elliot, you will have a smile, but let's say I have like a Canadian or European client with, so usually they're small. Their generative AI is not at scale. So, but they own the IP. They want to partner with, let's say, a company in China. All the IP that will be generated by the machine will be potentially co-owned by both parties, but captive in China, because the health data, as per my understanding, and I worked in it as well, health data doesn't cross border easily. So how do I help my customer to protect their IP when the generation of the new IP is kind of obscured to them or like captive in a certain geography?
Vivian?
To chip in, so and Elliot will talk more from the IP perspective, but in relation to data protection, cybersecurity, Gen AI in China, you may not expect it, but actually here in mainland China, the government has already published a lot of regulations, laws, standards in relation to generative AI, and you actually may expect it from a country which is, well, communist regime, very, very strict on any publication and advertising. So usually Gen AI is used to publish the content, right? And so this is where you need to be very careful about all the Chinese laws and policies in relation to advertising, publication, nothing against national interest, state security, okay, but also the laws in China on Gen AI. There is regulations since 2022, last year, 2023, very important regulations specifically on Gen AI to avoid deep fakes, because the Chinese government wants to censor that very, very strictly for sure. You can count on the Chinese cyber police to be very attentive to that. But Elliot, maybe you wanted also to share from an IP perspective your input.
But I think, unfortunately, in this particular case, the overlap between government policy and IP is quite strong. China is at the moment in the throes of finalizing its the equivalent of the AI Act, and there have been a few drafts that have been out there. I think the key risk there is unintended consequences, and Vivian touched on it very briefly. From an AI perspective, there have been a few clients actually, including some number of Canadian clients, who have inquired, and British clients who have inquired about what do? We want to have our team being able to use the Gen AI tool in China, but how do we make sure we don't fall foul of the regulators? The short answer will be, well, it depends what your input IP to the Gen AI is. And the risk that you have is if you've got outside China IP that goes into it, or material that goes into it, then you have an unintended consequence when you put in a query and all of a sudden it comes out with, I'm being very aggressive here, a body of Winnie the Pooh with the head of Xi Jinping. Bang, you've got a huge problem in China. Whereas everywhere else, people have a little snigger about it. But in China, this, Winnie the Pooh apparently has become a pariah because that's the nickname for, Papa Xi. So from that perspective, the way that you can sort of say, without giving, without being very specific to the answer, is if you're using material that comes from China in relation to material that's going to be generated for China, you're probably a little bit safer there. But the real challenge is that you do have to look at what your input IP is and what's going to be generated, just to make sure you don't very accidentally fall foul of any of the regulations. And as Vivian pointed out, there are a number of regulations already in place, but they're not in a single place. Yeah, we were just recently, I did a lecture on China AI and IP for the Center of European Intellectual Property in Strasbourg. And there the key thing was that very often in Europe you can point to one or two, and in other countries, one or two key pieces of legislation. In China, you're looking at between 40 and 80 pieces of legislation regulations. So you can go through it, but you really just need to be a little bit careful because it's also fast evolving.
I was just going to add a point to that. For me, the source is looking at the contract first, even if it's a template, to see if it's what kind of data sharing agreement that's going to be in place, because that will give you some indications as to where the ownership is going to lie, whether it's going to be a I own, you own, or it's going to be a co-owned situation that will appear. Adding on to the body of legislation, obviously there's the European AI Act if you're going international, but you also have to look at what's happening domestically between Law 5 with the health data, Law 25 with respect to data privacy, to which I would add also European GDPR considerations, standard contractual clauses that have to be closed off as well, to make sure that you have all the authorizations from the data subjects that are coming into Canada, and from Canada having the right adequacy decisions to be able to post-process data and then be able to re-export it out into any one of the jurisdictions that are around the table today. So it's a bit of I would say it's a bit of a messy situation, but it's one that could be foreseen by way of contract and being able to reduce. Again, the concept is risk reduction, and that's what everyone around the table is here for, is to reduce that amount of risk for the entrepreneur, for the business that wants to engage in accessing new markets, international markets. Great question. Thank you.
We have one question online.
Yes, we do. So Rick asks the question, it's a two-parter. Is it possible to protect IP for a data analytics program? If so, what would the process look like?
For what?
The process for protecting data analytics program in terms like an educational program, I like to always refer to the model of what any online platform does. It looks at the amount of creative data, meaning content creation. That's one way of protecting the data. Then obviously there's the trademark, how we're able to use that in commerce. That's another way of having IP ownership over the type of program that we're offering through data analytics. And of course, there's always the contracts that you have to add on to with respect to copyright, and being able to protect and to be able to enforce when wrongdoers are copying course content. And when we look at course content, we can think of rights of use, rights of image rights, likeliness of image rights as well that have to be considered. And this is where we really have to do a parallel between Canadian law, Quebec law, as well as, for instance, US law. And then my colleagues internationally can chime in with respect to their domestic laws as well. But these are all the types of considerations when you're looking at a program that's being taught domestically and then internationally.
We have question online, I guess.
We'll take one more question.
No?
I give you an example. I began writing a book, and from which once I asked ChatGPT to give me main questions I could ask for that reflection, and I accumulated maybe 700 questions. After give me more, give me more, give me more. And then the problem is that first, the source I use does not display copyrights. I don't know the source, but I need to confess I didn't ask. Okay, maybe I should ask ChatGPT, can you give me any copyright infringement? So, but I'm not sure it would be able to give it. So that's the first part. The source we ask from AI, sometimes we don't know where it comes from. And there are two possibilities, a bit of many source, a bit for each one, or a lot from the same source. You never know, okay? And the other problem is when our content someday might be put into the AI and people will use it and they won't see that it comes from our source. So do you know any kind of reflection around that? I mean, just a comment before I give my clue back. What I hear is that it's a big load of rules, but I just imagine what it would be if there would not be any rule, like the Far West, it would be worse.
Hence the reference to A Million Ways to Die in the West, right? So in order to respond in part to your question, the way that we look at any AI solution is we look at it from a perspective of what our inputs and what versus what our outputs are. In the US, we know that the US Copyright Office has to have an accreditation you have to mention what was developed by AI before even filing in the US. Now, WIPO has taken, the World Intellectual Property Organization has taken a different perspective of it, being able to look at it from one where we are trying to not only source what is the inputs versus the outputs, but also the question of originality and the human intervention requirement. And this is front and center topics that are being held there currently. Now, as to how each national office will look at that in terms of the degree of human intervention, the degree of originality, that's where case law is going to be going towards. In the US, I don't know if Matthew has an answer to this or not, but there's over 30 court cases ongoing about this particular concept of infringement and copyright ownership, if you like, to that material. Whereas in Canada, we only have one case that's before, or one or two cases before the Federal Court of Canada, where they're trying to figure that out. It's too soon to tell, but from a European position as well, they have certain opinions that say any type of input that you're putting in is almost, I don't know if it's accepted yet, but it would be considered infringing material already when it's coming in. So that's
the prompt being
not the prompt, the content that's being imported in order to get into the decision-making process.
Yeah, because that's the main.
That's
range of this
exactly.
model.
And we don't know where that necessarily is coming from, whether it's from jurisdiction to jurisdiction. The concept of web scraping could be legal in some and illegal in others. So you really have to be able to do that due diligence and dig as to where is that content being created, sourced, and is it authorized or not. So that's it. I will just go back to my podium. So I just wanted to first of all, give a few key takeaways that have been discussed earlier today. So the number one key takeaways is order your combo in advance and be ready to have it to go. Timing is critical. Know the IP related deadlines when entering foreign markets, and budget your international expansion as IP related costs can increase significantly quickly. Other key takeaways is to have your IP house in order, that the value creators must outweigh the value destructors, know your budget, but we also are proposing the concept of flywheels and being able to know how to leverage the different grants and incentives, tax credits, government programs that are available to make you grow your business, to be able to maximize your value. This is something that is absolutely pivotal. Also perform with any of our colleagues here to perform checks, landscapes, do your due diligence, and always be doing risk assessments frequently, because you never know when something will pop out, whether it'll be a third-party infringement or not. Next slide, we have also added some other key takeaways there as well. And the next slide, we have our resources page, in which we'll be adding some content that you'll be able to view from FORPIC as well as our partners to stay up to date as to the recent IP topics. And I just wanted to present 3 slides very quickly. Next slide. This is what the process is when you're undertaking international expansion from an IP perspective. So how you do your landscape, what does the decision tree look like in order to arrive to whether or not, yes, you can get some form of IP protection or not. Next slide. And also with respect to the consideration of whether you have a new product entering a new market, or whether it's an old product, being a Canadian product, that you have to create an improvement on in order to enter the new market. So these are all the considerations, and we're making this available for you to be able to have a sense of the type of situation that you're engaging into. Next slide. And that's the 3rd slide that summarizes it. And the next slide will be our thank you. And I would like to thank Gowling WLG for hosting FORPIC at your Montreal offices, as well as from our panelists, Gowling WLG. I'm referring to not only the Montreal, but the Paris, Dubai, and China offices for being here and staying up so late. Thank you very much. I would also like to thank the Canadian Trade Commissioner Service. Thank you very much, Eric. Thank you very much, Frédéric, for coming. To Lippis Matthew Asbell in New York City, as well as MVIP, represented by Chris Turi here as well as all the participants for having attended both in person and online. Please check www.forpic.com for more information, as well as those of our partners for more information on FORPIC 2025. Thank you very much.
Thank you very much, and if you want to enjoy some more breakfast, coffee, you're welcome to mention the village.